Our focus for the second quarter of 2022 is on helping clients understand the impact of asset ownership and beneficiary designations on how assets transition to heirs. While most of us want to use smart strategies for reducing estate taxes, be certain our personal values are communicated through our plans, and perhaps ensure the responsible use of funds, we should also periodically review our plans to ensure our assets will actually pass to our desired beneficiaries. Through other communications this quarter, we broadly discuss how various account types transition to heirs at death. Today, we want to focus on one of the most common questions we receive. Who should I name as beneficiary of my individual retirement account? Well, the ideal beneficiary depends on your goals and should be considered in the context of your overall plan. In general, you may want to consider the following. Who do you want to have use of the funds? The estate and income taxes that may apply, how quickly the beneficiary will be forced to withdraw the funds, and any desired control or limits on when or how the beneficiary uses the funds. With these factors in mind, let's walk through a few of the common beneficiaries and relevant considerations. Surviving spouses are eligible for a spousal rollover, which simply transfers the balance of their deceased spouse's IRA into their personal IRA. Through this mechanism, a surviving spouse generally enjoys the most flexibility in terms of the timing for withdrawing funds from retirement accounts. So long as both spouses are U.S. citizens, no estate taxes will apply to this transfer. However, this can result in larger distributions to beneficiaries following the death of the second spouse, possibly leading to higher income taxes if the IRA is a pre-tax or not a Roth IRA. Also, for blended families, this may not be desirable as the goal may be to transition wealth to children from a prior marriage. If funds are not needed for the surviving spouse or other individuals, charities enjoy absolutely the most tax benefits as neither income taxes or estate taxes apply. In fact, if any funds are going to transfer to charity at the time of your death, a traditional pre-tax IRA is generally the ideal source for the gift. Following the SECURE Act, which limits the time frame for distributions to most heirs to 10 years, charitable remainder trusts have emerged as an opportunity to stretch distributions to family over a longer period of time while also providing for a charitable gift. Non-spouse individuals, such as children or siblings, generally must withdraw funds within 10 years of the date of death of the IRA owner. Now, there is pending clarification to the SECURE Act that could impact this time frame based on whether the original IRA owner was subject to required minimum distributions each year at the time of their death. If these individuals are directly named, they have the option of either taking the funds all at once or spreading the distributions out over the allowable window. For families that want some controls in place so that the funds are not immediately withdrawn, trust can be named as beneficiaries of IRAs. However, there are a number of pitfalls to avoid, and the optimal approach will likely involve the concept of a conduit trust and some detailed planning with your estate planning attorney. This approach should not be taken casually, as it can create significant complexity and some negative tax consequences. Likewise, naming your estate as a beneficiary can add complexity and reduce tax planning opportunities. We strongly encourage all of our clients to name both a primary and contingent beneficiary to avoid a circumstance where a probate could be required if the primary beneficiary is not available to receive the funds. As always, your Ferguson Wellman and West Baring team are here to support you in collaboration with your tax and legal advisors. Make it a great day.